I have Wiggins.
Lindsay, I'll hit you next.
Wiggins is the one that Anna is on. So I asked your clerk to put the motion to appoint second chair in your queue.
Fine.
He's set today. Anna wants him set Monday to address.
Have Wiggins?
Yes, he is here.
Bring him out.
So I spoke with.
Oh, we're not just talking court motions, we're naming names and throwing shade. Welcome to Courtroom Politics, where Mikey and second chairs matter more than you'd think.
I guess it's a term of endearment.
It is a term of endearment. That's why I let him call me.
It is a term of endearment. I try to have some level of respect and not do it while at the bench. But I spoke to Mikey, and
It's Chief Mikey.
Chief Mike.
He's busy chiefing, Judge. So the jail calls exist in two separate computer systems. So they do exist, and a DA has listened to them, but their ability to listen to them is separate from them having their ability to share them. So they have requested the files be duplicated, and that has not happened. So they do exist, and they confirmed and they've listened. We don't have copies.
Have you listened to them?
We don't have them yet, Judge. They've been requested. They have not been uploaded.
But have you listened to them?
No.
So,
To my understanding, can I listen to them before they're?
and speaking of Mr. Haddad, there was a note from a prosecutor that had. So,
I just want to know if it's true.
so third person hearsay for Mr. Haddad, yes.
So, Judge, there's a software called Virus in which the state can listen to all jail calls made by securities, I'm sure you know. But we don't have them in our possession until they're requested. I just saw a note from a prosecutor that they may have listened to a call, but that's, like Munir said, it's hearsay. I don't really know if that's true. I just know that we have requested them last week, but they're not in the portal for the defense to access quite yet.
Who listened to them?
That was the deputy or the investigator last week who made the phone call. I think the felony prosecutors.
So can they confirm what the allegation is? Because I don't want to keep him in Ag Seg if he didn't do it. I want to put him in Gen Pop if he's been good. But if he's not.
I will say Ag Seg versus Gen Pop, not going to change the.
Jail calls, threats, and hearsays like an episode of Better Call Saul, but seriously, without the actual recordings. It's all smoke and no fire.
Know that though, because who knows who he's calling, who knows what he's saying for something to get done out there while he's in here.
I don't think there's any allegations of him speaking to a third party about any of this.
Well, Judge, even though we may not have personally listened to them, we have the complainant that she's the one that reported it to begin with, that she was receiving the threats from this defendant. That's how we know, Judge.
How long until I get the actual phone calls?
They were requested last week.
So, Judge, they usually take a couple weeks to actually get them to evidence. I would say 2 weeks.
I'm trying to get the phone calls as quick as possible so that we can verify what the allegation is.
Listen out there. Don't speak. Don't. No.
You know,
Don't question.
I'm just telling you, from the last hearing that we had, what the allegation is. The complaining witnesses also come forward to verify that there have been threatening phone calls.
I can give you a recitation of the facts, not in front of all of these people. So I'll talk to you about that in the back.
When we mean no threats, we mean no threats. So understand, I'm trying to get it as quick as possible so that we can move forward. I don't want to keep you in Ag Seg if it's not true, right?
I know Ms. Edie wishes to address the segregation unit.
This isn't just about threats, it's about who controls the narrative behind bars. Should a defendant sit in solitary based on a phone call someone might have heard
Before the bench last week. I have notes in here that you admitted that he just said.
Can you get them as soon as humanly possible so we can make this definitive one way or the other,
Yes,
please?
Judge. They were immediately requested.
Do you think that we should subpoena the officer here? Would that make things go quicker?
No, Judge, I mean, generally, the jail has received our requests. It just takes a little bit of time because generally these are hundreds, thousands of calls that they have to put on the portal, Judge. It takes time. We just need a little bit of time. That's it.
My understanding with my conversation with Mr. Haddad is that they can be listened to by the DA now. So if you like, we can send somebody, like I can go with the DA and the,
Listen to it too?
Well, yeah, Judge, the problem is, again, there's thousands of these calls most likely. So to actually get to the call where we know the threat was made is going to take a long time. We need the investigator to give us the date and time.
Imagine the logistics of trying to identify the phone call, the time.
well, my understanding is it's like a filter. You just put in either the time and date or even the number dialed. So I think you would have the CW's number.
We put it off for one more week since it's already been a week?
Can we do two, Judge? I think if we do two, I mean, it's not gonna, and if we get them beforehand, Conrad will do his due diligence. He will contact Munir. We can get it on the docket earlier than 2 weeks, but I don't want to keep putting it on when Mr. Wiggins is not gonna get anything out of it.
I want to send Monday to address the SEG because while I'm here and speaking confidently about one thing, Miss Edie is going to speak confidently about another, which is the segregation, and I have no information about how that works. I know she wishes to have a conversation with the court. So I asked to keep them on Monday.
Yes.
And assuming that they can listen to them, figure out how, perhaps we can all go into a room on Monday and do that very quickly.
Let's see.
Yes, Judge.
If you can, wonderful. Let's try it.
All right, thank you.
Okay. All right. Mr. Wiggins, we'll see you Monday.
Thank you.
Hi, guys.
I'll bring her 2 hours right now.
Nathan, anything else you wanted to talk about?
I've got another client who is considering plea. And if she makes a decision to plea, I might have to preview it to you to make sure you would accept. Last name Kurtz, K.I. Nolan Kurtz, his last name.
Is it a DBI second?
No, it's a first, PTI, she was unsuccessful. She was on it
I'm
for
okay
some
with
time.
it. You want time served?
Yeah,
I'm okay with it.
okay. She's still
As
considering it
long
now.
as it's not like a second.
No, it's not a second.
No,
She's considering it now.
she's in PTI now.
She was just kicked out of it.
She was kicked out.
Yes.
They don't want to keep running.
No, she tested positive once, I think in March, had a traumatic June, admitted to consuming alcohol in June after being placed on zero tolerance. And then there were some skip tests on the blow and go.
Okay. You guys tell me what you want to do.
Well, she's making a decision now. So,
If, I'm going to set up a drop.
well, and that's her decision is to either plea or
So
say
what, Kurtz, you said with a K?
Nolan Kurtz. Last name is both Nolan and then Kurtz. Is that?
Oh, it's 565, so it gets like a very short,
Yeah, yeah.
tell her it's a short trial setting.
So I don't know grammar. What is a straight line?
A hyphen.
A hyphen. So Nolan hyphen Kurtz. This shows you how much I paid attention in English.
Washington.